versus Katherine Henry.
This is a public service.
File 203569SM. Let's proceed. We have several motions here. So
I'm to Your Honor, but I can just start with my motion to regarding declaratory relief regarding the ability to file a motion to dismiss.
well, you've already filed a motion to dismiss, correct?
Yes, Your Honor.
Okay. So
The last time we were here on a motion filed by myself, Your Honor, there was a ruling that I was not allowed to file any motions to dismiss in this case. So
well, your motion was denied.
right,
So yeah, that's what was happening. It wasn't that you weren't allowed to file the motion. Your motion was denied.
denied because I wasn't allowed to file a motion to dismiss. So that's why I put together the.
Okay. All right. Go ahead.
So if at this juncture, Your Honor, there's a different understanding of my right to file a motion to dismiss, then I don't need to waste your time on that motion. That's the only reason why I put that one together, Your Honor.
Okay. Next motion.
I'm also, I guess I would go to motion to dismiss the disturbing the peace charge.
Actually, since you indicated you don't have a preference as to which to go forward with,
That's correct.
I would prefer that we proceed on the. Are you going to be proceeding with a motion to dismiss on the trespass as well?
Yes, Your Honor.
All right, because I saw that, and I would prefer to go on that one first, and the reason being, the disturbing the peace is predicate upon trespass, correct? Were it not for the trespass allegations in charge, there would be no allegations of disturbing the peace, correct?
Actually, that's part of what I filed. The complaint doesn't indicate anything, and no discovery was ever provided for that. So I don't know what the frame of reference is for that charge, Your Honor. Well,
in any event, let's proceed with the trespass.
Yes, Your Honor. The last time I filed a motion to dismiss, it was based on different, some of the same underlying legal issues, such as, for example, the First Amendment, right to free speech, and petition government for redress of grievances, et cetera. However, the specific mechanism, if you will, for that was, it was served incorrectly. So I had filed it as a 2.116C2 motion. The process by which I was served was done incorrectly, so I had filed it as a C3 motion, and et cetera. So let's go
to the merits of your dismissal for the trespass.
Yes, I'm just distinguishing because I was kind of jumping to the answer that was provided by the prosecutor, Your Honor, saying.
Let's address they can raise their issues, and if you want to take a bite at that once they do that, let's do that. But just to keep it in a single line of thought, let's start with our trespass concerns, and I'll jump in on this for you because my reading of your motion and then the brief indicates that the vehicle in question, as according to you, and in your statements, and you're indicating there that it's uncontroverted, so that's what I'm going to inquire of the prosecutor in a moment on this. Is it your position that this vehicle was fully off the pavement and in the grass?
Oh, my vehicle, yes, Your Honor.
Okay. All right. And that's the vehicle that you're referring to that was fully off the pavement and in the grass, is the vehicle that is in reference to the trespass, correct?
When I just used that word, I meant the avenue that I took was using MCR's 2.116 C2 and 3 and 8 and 10 last time. I didn't mean to use the word vehicle in terms of like literally my car. So I apologize for any misunderstanding there.
Well, but you're talking about you are referencing a vehicle in your brief, correct? You're saying the vehicle was fully off the pavement and in the grass.
Yes, I mean, as a matter of law, though, the trespassing statute has nothing to do with the vehicle being there. A civil trespass would be trespass of chattels. That could be something, but there's no trespassing of a vehicle for the criminal trespass statute. So I don't think that's what's alleged by the prosecution either.
Well, maybe we should be clear on that. I want to be clear on that. Ms. Roy?
The question is?
Well, is the basis of the trespass the vehicle and whether or not the vehicle was in the parking lot of Layton Township?
The basis of the trespass is a combination of both the vehicle, where it was, and you're correct in what you stated before on the record, and the fact that Ms. Henry would not leave when she was asked to do so.
All right, but that's going a bit further than I wanted to go with it, but you're indicating, so the vehicle in question, was it in the parking lot or was it off the parking lot in the grass?
It was on the grass, Your Honor.
It was on the grass. So this is an interesting development for me because my understanding is the basis of the trespass being alleged was that vehicle was potentially impeding the ingress and egress of individuals to vote that day, and thereby, and I, at least when on my first impression of the case, was that it was in the parking lot. But if it was outside the parking lot, how would that be impeding ingress or egress?
Well, what we believe, Your Honor, is that the clerk is going to testify that through her years of experience, plus what was going on this day, it was a very large turnout, and what the vehicle did and the setup that they had going on that particular day caused a problem with people coming in and out of the parking lot, and that setup was causing an egress, regress type of issue with the setup they had there.
Well, maybe not. And I'm not going to get into the, pardon the pun, I'm not going to get off into the grass or the weeds on that argument as to whether or not it made things more difficult. But if they're not on the pavement provided for parking and ingress and egress, and they are beyond the statutory measurements as to where individuals can assemble, even if it creates some difficulty or some hardships, isn't that something that's envisioned that they're able to do?
The answer, I think, to that question is, Judge, that the problem becomes if this is allowed, then what happens is if we have more than just this group of individuals, because this is a constant. Sure. There could be lots of individuals that lots of different groups. Right. That might want to do it, but all of them would have the right to do that, right? If they are outside the curtilage of the very specific measurements set out for where parties can assemble outside voting precincts, correct? There's some very specific measurements provided. And then once they're beyond that, and they are also not on the parking area or the ingress egress, there could be lots of different groups, and it may look messy, but sometimes democracy is messy. The problem, Your Honor, is it wasn't just at the edge of the grass. They were on the edge of the grass, and their activities for lack of a better phrase, led onto the pavement. They were actually working on the pavement as what we believe the testimony is going to talk about. They actually were working on the pavement and working back and forth where vehicles were traveling and coming back and forth. And so it wasn't just they were working off on the grass, they were actually working onto the pavement. And so it wasn't just off the pavement that they were working on. They were parked off the pavement, but they were working onto the pavement.
All right. Well, let me.
May I have for clarification, Your Honor?
Sure.
I don't know if this is going to be relevant or not to your inquiry, but as far as the activities that are mentioned, I don't think this is disputed either, but when I talked to the deputy over the phone before I got there, we were trying to resolve this regarding the 2, at times 3 petition circulators that had been there. He was threatening to arrest them for trespass. My only presence was there as the attorney for the petition and for the circulator. So I wasn't participating in any activities other than literally waiting for the deputy to come back because he was expecting to talk with me. So yeah, I don't know if that changes anything, Your Honor.
Well, I mean, I appreciate your statement. I mean, yes, I guess that it does clarify in regard, since this is a charge brought against you, but I'm still struggling with the point of because this is different than my original understanding of the matter. I was, and maybe it was just my assumption, perhaps I shouldn't do that, but when we were talking about the vehicle being parked and that was interfering with the ability of individuals to ingress and egress for purposes of voting on a day, granted, of very high turnout, yes, I agree with that. So, but if it's not in the parking lot, I just don't, how does that not actually infringe on their rights to peaceably assemble and to protest if they wish to protest? But they weren't protesting, they were gathering signatures. But in any event, I mean, yeah, it seems to me that they would be well within their rights there. In fact, wouldn't opposing political parties have the right to do that if they chose, and oftentimes do?
The problem, Your Honor, is that if the activities were to, you're correct, that they oftentimes could or do, if those activities bump up onto the pavement and then we have these groups doing that, then they impede the ability to do the people's business, in this case, the voting. And in this case, that's what was going on, was the activities were on the blacktop, and that's where the activity was. The car was off on the grass. You asked a very specific question.
Well, yeah, well, right, because I was given to understand in our first hearing on this specific subject was, you know, my understanding was that the vehicle was actually in the parking area. Now, those other individuals that were up on the pavement and interfering with, you say potentially interfering with the ingress egress for voting purposes. And I agree that would be something that would be concerning if, and in particularly if they are not respecting the curtilage rules for voting area. But that would be something, I guess, that could be addressed with those individuals. But if this is not the individual that was doing that, how do we see that?
You mean as to this individual, this defendant?
Right. This individual is the individual that's, you know, being charged. Right.
And so what we believe the testimony
we're not charging her with the actions of others, are we?
No.
Okay. No. So we've got a vehicle here that is not in the pavement area. It's not impacting vehicle ingress egress. We've got some people, according to you, and I don't know, I'm going to assume what you're saying is correct, but for the time being now, you're saying that some people were going up onto the pavement, and that may or may not have, I don't know, but again, we'll just assume that that may have had an impact on individuals gaining access to voting and to leave after voting. How do we tie that to Ms. Henry?
We believe the testimony will show that Deputy Langlos went out to the scene first and spoke to the folks at the scene and came up with a compromise where those folks at the back of this vehicle would bring in their signs, bring in their table, and bring it into the back of the vehicle, and they would just stay there off the pavement, and that's where it would stay. And they would be able to stay there, and that's where they were allowed to keep collecting their signatures.
Okay.
And then within about an hour and a half or so, approximately, they were called back to the scene where they were told that Ms. Henry had arrived, and she had told them to put everything back out onto the area, which included the area of the pavement, and to put all the signs back out and to go back out and to do what was originally causing the disturbance that the clerk had indicated was causing a problem with the parking and the egress and regress of the vehicles. And that was causing the problem that caused the clerk to come out and say, would you please leave? And that was leading to the trespass complaint. We believe that's what the testimony will show.
So you're saying then they were asked to go to the edge of the pavement and go beyond that for their setup, and they complied with that, and then they came back out onto, and that is what is constituting the trespass, and that was done as a consequence of the directive of Ms. Henry.
That's correct.
All right. Okay. All right.
Your Honor, I guess to that point, that's the first time I've heard that.
Me too.
I'm sorry,
So
what's that?
for me as well, it seems go ahead.
I guess my thought on that is that I think the statute is pretty clear. Trespassing does not, let's assume for the time being that all of the facts he's suggesting are true. The statute clearly does not cover me instructing others to trespass or to be in some sort of area that they don't legally have permission to be. It clearly is talking about where I am physically, that I'm somewhere where I don't have the legal permission to be. So regardless of whether I was, cheering somebody on to do something that led to them committing a legal offense or not, it has no bearing on whether I was trespassing.
So she's not charged with an incitement, is she? She's not charged with anything like that, or even obstruction. Frankly, she's charged with trespass herself.
Right, Judge. I'm not here to try all of the case. I'm not trying all the case. I'm trying to address with the single issue of whether or not the trespass matter should be dismissed or not. Furthermore, the evidence we believe will show, I didn't think I was going to go through all the evidence that I think was going to show, but that she was told, Ms. Henry was told, that this group had to leave, and that this defendant in particular was directing people to stay put, to not to go. She was the one in charge of the situation. She was the one, according to the deputies, that was clearly in charge of the group there.
She's not charged with being in charge of a group. She's charged with physical trespass herself.
Correct. And
that's what we're concerned with.
Correct. And she was the one that was there, and she was the one that was telling people to stay, and she was the one that was being asked to leave, and she was the one that was being asked to leave by the clerk, and she refused to go, and then she was asked to go by the deputies, and she didn't go.
But just being asked to leave isn't enough of a reason, is it? That's not enough of a basis to proceed on trespass if you don't have the authority to ask someone to leave.
She is, according to the trespass statute that was adopted in July of 2022, which is the model jury instruction, I have to show that she's come onto the property, that it's property owned or occupied by the township, that the township had the property, she had the authority to, that being the clerk, had the authority to tell them to leave the property.
That's where I'm hung up right now, because that is frankly why I put this motion out, to get your response to her allegations in regard to the trespass. Because with her statements indicating that things were the vehicle, and that was really the central matter for, at least as it was argued to me initially, with the vehicle impeding the ingress and egress. Right now, it sounds like if the vehicle was not on the pavement and it's outside that measurement required by the Secretary of State for voting access, what is her authority to ask someone to leave?
Her authority is that these people's activities were doing the egress and regress, blocking their activities. And so she used she mentioned a resolution that the township passed, and that is the resolution that she brought out to Ms. Henry and to the others, that the township passed in 2016. And that was the authority that she cited to Ms. Henry.
Well, but a township can't pass an ordinance that would subvert or infringe upon a constitutional right, can they?
Not a constitutional right, no, Your Honor.
Well, and isn't the right isn't the First Amendment a constitutional right? I mean, because that's what they're indicating of freedom of speech, and they're attempting to gain access and signatures for a petition drive. Correct?
Correct.
And they were outside the stated parameters required, correct?
They're outside the 100-foot rule. That's in the...
Well, they were substantially further back than that even.
Yes,
weren't they?
They were, yes.
Okay. And so well beyond that. And they were off the pavement, so they weren't impacting the ingress and egress with their vehicle, were they?
What we believe the testimony will show is that the clerk will testify that their activities and their setup was impacting the egress and regress of their activities at the voting place.
They have a right to be there. And
we're not,
unless there is some and let's be real thoughtful about this, because this is not how I had originally understood this case. I understood that this vehicle was on the pavement in the parking lot, potentially interfering with ingress egress of individuals with an attempt to for access to vote. And the circumstance now is there may well be a group of people on the perimeter of that parking lot, but I don't see how that is something that is not allowed. And more than that, more specifically than that, I don't see how it gives the authority for someone to instruct Ms. Henry to leave.
well, I think what the response, Judge, to that is that it's not their right to be there that we're challenging. It's what they were doing with their right that we're challenging. And that is
Collecting signatures?
Now, it was the fact that they were using the space in such a way that they were not able to use, the township was not able to use their space in a way that was allowing the egress, regress of the vehicles in such a way over this time period that the clerk is going to testify it was a problem. And that's why they asked for the folks to leave. So it's not the right that we're challenging here. We're talking about the fact that
It sounds like it is.
Sorry.
Because, well, I'm not asking you to be sorry about that. I'm trying to understand because we have individuals that are on the perimeter of the parking area. And they are collecting signatures. Now, yeah, that may have some interaction with people wishing to vote. Granted, but that happens when people go to vote at, let's just say, the fire station or at a local school, and there's a line of individuals supporting one party or another, or one cause or another, and trying to talk to people and hand information to them or chant. That may be happening, and it does happen. But I don't think that I don't see how someone on the edge of a parking lot is impeding, and I certainly don't see how that would apply to Ms. Henry. I don't. Do you have a way that we're going to be able to tie that in?
Well, I tried my best to explain it. I'm leaving the rest to my briefs. I think that's the best I can explain it to the board.
What was Ms. Henry doing that constituted the trespass?
Ms. Henry did not did not leave after being told she was asked to leave the property by the township clerk several times. And at that point, she was arrested for trespassing.
I got to tell you, this turn of events is rather surprising to me. I was definitely under the impression that this was the basis of this case was due to the fact that this vehicle was impeding ingress and egress, or potentially impeding ingress and egress to voting, which is obviously fundamental right to other individuals. We don't want to, enhance one person's rights over another person's rights to exercise their right to vote. However, there's very specific guidelines for when and where individuals are allowed to assemble to express their either grievances or express their statements, whatever statements they wish to make pursuant to the First Amendment, peaceable assembly. I don't see, by way of this discussion and by our discussion here today, I fully expected you to say that actually the vehicle was in the parking lot, and that's why we were so concerned, because it was actually in the actual physical space that would be impeding ingress and egress into this voting space, which would, in my opinion, provide the township with the proper authority to be able to say, you cannot be here.
Well, I'd like to just be clear. I watched the video several times, and
I want to be clear. I have not watched the video at all. I'm operating on the pleadings and the statements that have been made in court. So that was my understanding of what we were talking about.
And my interpretation of what I saw was the vehicle was off on the grass, so there's no question about that.
And I appreciate that. I want you to be forthright about that.
Right.
You have an obligation to.
I do, and I would never short this court.
And I agree that You would never do that.
Thank you. The only thing that I'm arguing then is the tables and the persons were onto the pavement, and that is the activity for which we are talking about as the egress and regress issues for which the township is taking issue with Ms. Henry and the trespass. And that's the issue that we're talking about, was on the pavement. And I don't want to rehash it. I just want to tell you that's the issue.
I understood that. I understood that. I mean, we're talking about constitutional rights, but also from a point of view of actually understanding the specifics. I'm familiar with that parking lot. It's rather large. And I don't want to get into the minutia of detail in regard to, well, how large is large enough to allow this and whether or not that's going to impact or disadvantage individuals from coming to the lot. But the point is they're well beyond the mandatory measurements as to where people could assemble. And they're not on that pavement at all. We haven't heard, we've heard that Ms. Henry came to address concerns that were raised. Sounds like she came to address concerns that were frankly already resolved, and then she created more concerns, but that's something that I guess you can do. Generally, at that point, at least, making it a situation that was viable and workable and making it, not viable. But from a point of view of whether or not this constitutes trespass, I'm really struggling to see the basis that the township clerk would have had the authority upon which the township clerk would rely to make this order to have Ms. Henry leave the premises. I think that's an essential element. I'm going to dismiss the trespass charge. The next thing that would come to mind is the disturbing the peace. But for the trespass, is there disturbing the peace?
Is that a question to me, Your Honor?
It is a question to you.
All right, I'm sorry. I did want to make sure. I believe the answer to that is no, in this sense. The clerk, I believe, will testify that she was regularly engaged in trying to keep the election flowing and going. And as a result of this, she was interrupted several times trying to deal with this group and then eventually trying to deal with Ms. Henry in particular. And she, as a result of that, had to deal with Ms. Henry on this basis, and as a result, as the disturbing the peace talks about, she engaged in conduct that went well beyond stating just her position or personal opinion. She was yelling and screaming and dealing with the deputies in a way that didn't have to be dealt with in that way.
But wasn't the yelling and screaming dealing with the trespass?
No, Your Honor, it's my arrest. I'm sorry.
Well, the arrest for the trespass, though, correct?
It was literally as I was being taken to the car. Yes, Your Honor.
But it was for the trespass.
Yes, Your Honor.
So the answer was yes.
Yes, Your Honor.
All right. All right, you can have a seat. Right?
If the court is asking me if the disturbing is.
The disturbing the peace is predicate on that trespass, right?
If the issue is it follows that the disturbing comes mostly after the trespassing, the answer is yes to that point.
The disturbing the peace charge is stemming from her actions when they were attempting to arrest her for the trespass. Is that correct? Or is that not what you're charging? Because let's be clear. I mean, this case proceeded on trespass only until well into the case, didn't it?
That's true.
The amendment for disturbing the peace was quite a lot later.
Yes.
And again, maybe you can clarify for me if it wasn't the case that the disturbing the peace is a matter that is predicate upon the trespass, then that's something I'm interested in hearing.
If the question is implied, then why it wasn't charged originally, I don't have the answer.
Oh, and no, I wasn't trying to imply that. You have the right to do that. You have the right to try even during the pendency of a trial. I mean, I'm not questioning that. You might scratch your head a little bit as to why wouldn't it be charged if that's what you thought was going on, but you have a right to amend your charges once you make a determination that you believe that this action constitutes a criminal action. But the question that I'm asking, Mr. Roy, is if the actions associated with the trespass were not with proper authority, doesn't someone have a right to protest or even resist arrest if it's considered to be without proper authority?
Under the way the court has formed that question, I would say yes.
Do we have anything else to talk about here?
I don't know, Judge.
I consider the charge of disturbing the peace to be predicate upon the trespass, which I've already indicated was without proper authority. Thereby, I'm going to dismiss the disturbing the peace case.
Your Honor, I'd like to clarify my position with regard to my remaining motions that.
There is no basis. Your remaining motions are.
Just one, Your Honor, just the redacted, Your Honor. That's it.
The redacting, we follow through on redacting pursuant to the law.
I'm sorry.
Pursuant to the law. And there are,
Right.
That's fine. Redacting, at least the identification on captions is something that's required.
I'm sorry, Your Honor. The information that I had originally requested to be redacted was my date of birth and my driver's license.
And that should be redacted now.
And then the only other thing I would ask, Your Honor, is with the new court rule, there's the ability to ask for other potentially protected personal information. The only other thing I would ask, Your Honor, is for my personal cell phone number, because I've had quite a few people calling my personal cell phone number, and I'm just trying to keep that.
Well, I don't know about that, but
That's
Do
not required to
you,
be
do
on-
you place that out there on the YouTube and stuff like that? Perhaps, I don't know.
No, not my.
I know you have a presence on YouTube, at
Yeah.
least people have told me you do.
I have an office number, so that's
You
what's out
can,
there.
I don't have a problem with you providing an office number in substitution of your cell phone.
Okay, so I just want to clarify then, do you want me to submit the form that, since I originally filed this motion, the SCAO has now created a form for an ex parte motion for redacting. Do you want me to fill that out to submit to you?
Sure, you can do that.
And then my only other, Your Honor, I do have the MC 392 and 262. I don't know if you were planning on using for the order of dismissal and the order regarding destruction of the arrest record.
Well, if you prepared one, why don't you show it to Mr. Roy?
I don't, I apparently didn't, I don't know where my filled out one is. I have them, I have the blank ones here with me.
If you want to prepare one and you can show it to Mr. Roy and then we can, either they can approve as to form only, or they can, object to it. And if there's an objection, we can address that, but I'm fine. If Mr. Roy is an eminently honorable individual. So I would expect you'd be able to have a conversation as to the manner in which we enter this order.
We're out here today to ensure our natural rights are respected by those who swore an oath to support, protect, and defend the rights of the people. The purpose of all interactions is to peacefully promote government accountability and transparency. Please like, share, and subscribe so this message can reach as many people as possible. I implore you to peacefully seek redress to any and all of your grievances. This is a public service.